Welcome everyone to the Legal Queen live show. I am your host, Tracy Maloney, also a practicing family law solicitor with over 20 years of experience. Over the years, I've helped thousands of people win their divorce and finance cases, as well as their child custody cases. So if you think that you could benefit from some of my help, then by all means, think about joining our Discord community. On with the show. Let's kick off. Vict Joan, I've invited you up whenever you're ready. What's your question? You're on mute, by the way. Take yourself off mute. There we go. How can I help?
Thank you. I spoke to you last week on Discord.
Yeah.
I'm a week away from the first financial hearing. I've bombarded the solicitors. They've still not provided disclosure with Form E.
Yeah.
Is there any way the court can make them, or is there any penalties for them not providing this information? Because there's absolutely nothing I can do. I've submitted the chronology, but I can't obviously submit anything else because I've not had any disclosure from them yet.
Yeah.
It just seems like a waste of an appointment that we're going to turn up there and I've not been given any information.
No, I hear you. I mean, to answer your first question, is there anything the court can do? Absolutely, but you're going to need to attend court. Okay, so
Yes.
you're going to have to actually attend the first appointment and let the judge know that it won't be effective because you don't have their information. I would suggest that it's most likely not his solicitors. They're probably doing all they can. He or she just isn't providing it to them. That's what I would be suggesting. But yeah, as tedious as it is, all you can do is attend court. Let the court know that you still don't have their disclosure. It now has to be ordered. The penalty that you spoke about, the court has the power to make an order in the absence of that evidence. So if they wish to counteract any of your arguments, they're going to have to provide that evidence. Okay, so that's probably the best penalty that I can think of. But yeah, first step, attend court and get that disclosure ordered.
Okay, that's great. Thank you very much for your help, Tracy.
Absolute pleasure. Thanks then. Bye-bye.
Hi, I'm just wondering, with a Form E and a conduct issues, I've sort of been informed that it's really, really difficult to make sort of conduct arguments. And the situation that I'm in is that behind my back, my ex-husband was he was self-employed. He was making far more money than I knew, spending it. He's in active addiction, but in denial about it. But he was also misusing funds under a power of attorney, which is going to obviously come to light now in disclosure. Is that a conduct argument, or is it just something that the judge may raise their eyebrows against?
It's definitely a financial conduct argument. Absolutely, Kat. Whether or not it's going to be relevant to your case, we would need an appointment to discuss that. But yes, based on the information that you've told me, that would definitely come under financial conduct.
Thank you.
Was that helpful? Was there anything else?
Very helpful. Yeah, it's just, we're only arguing over sort of the house at the moment, and he's got lots of inheritance in like his back pocket, but he spends money obviously like there's no tomorrow. So I'm hoping that I won't have to remortgage to give him a huge chunk. I know that obviously comes on a needs basis, but he would be able to house himself. He just chooses not to at the moment.
I see. So sometimes where we have financial misconduct and we have inheritance, okay, usually we can successfully ring fence any inheritance monies. But in this case, if you decide to run your financial conduct argument, it may be that you can convince the court to include the inheritance. And therefore, you are going to come away with slightly more of the matrimonial assets than if the court ring fences the inheritance. Do you see what I mean? Because then it's a win-win. The reason I say that you'd benefit from an appointment is because we would really need to drill down as to his misconduct. All right. And obviously, I don't want you to share this on a live platform such as we're on today. But you see where I'm going with it?
Yeah.
Okay.
Absolutely. Thanks.
Lovely. Okay. Absolute pleasure. No problem at all. So somebody over on the Instagram says, Tracy, I want to talk to you. Absolutely, more than happy. If you want to either drop me an email, maybe that was a request for a personal conversation because you need some one-on-one advice. That's fine. Or you want to come onto the Discord. For those of you that maybe aren't familiar with Discord, what I need you to do is to download the app and then create yourself a profile. And then you just come into the Legal Queen Lounge. It really is that simple. Tracy, I need one-on-one. How can I connect? Drop me an email. So that's how you would start, tracy@maloneyfamilylaw.com. My email is always in my bio on TikTok and on Instagram. So by all means, just drop me an email and we can see if we can help.
The final order only states some supervised sessions, which is for 8 weeks, and it's leaving us. So it says in the court orders that we have to agree on a parenting plan after this 8 weeks, supervised finishes. We've been doing supervised for the last, 8 months. And my question is, so obviously, if we can't agree, we are under Kafka's monitoring order as well for 6 months. So it's ending in October. So obviously that Kafka's person is the one who is going to, help us compromise and all those things. But he already says if we don't agree, so I don't think he wants to agree. If he takes me back to court and I have this final order with the the child lives with me, if he takes me back to court for another child arrangement because we can't agree on a parenting plan form, then does that mean I need to request this live with order again? Is it gonna override whatever is in my current final order?
Can you just tell me what the court order says? So you have a live with order for the children.
Yeah.
And then he has, did you say supervised contact for 8 months?
8 weeks.
8 weeks. And then after the 8 weeks, what then?
That's what the court order says. We need to send a parenting plan. We need to fill out a parenting plan, and we need to try to agree.
I see.
And if we can't,
I understand. So your question then is, if we can't agree on the parenting plan and he then decides to take me back to court, do I have to apply for the live with order again? No. The answer to that answer is no, you wouldn't. Because the point of disagreement or the clause that can't be agreed about is the parenting plan. The live with order wouldn't be up for debate anymore. It would be that part of the order that has broken down, and that's the part the court's going to deal with. I mean, your ex, there's nothing to stop your ex making an application to the court to say, well, I want the child to live with me, but I don't think he would succeed because the court's already made its mind up about where the child lives, and that's with you.
Mm-hmm. He wanted 50-50, but the court rejected on it already. Yeah. So he wouldn't, even if he applies, he wouldn't get it because the court already rejected even on 50. And the other thing is, if he takes me back to court, so he works only half a year, so that's why he applied for 50, 50 and 50 shared care. But the thing is, we live 100 miles away from each other. And how likely, because my son is only going to be 3 this summer, but he's going to from September, he's going to the preschool nursery. So I already have the confirmation. So if he takes me back to court, he knows all this, but he just, he says it's not compulsory, which I know it's not, but it's a preparation and it's in a benefit of the child. Would the court, I think they would take this into consideration that the child he already, attends nursery, but only a few days a week. But from September, he would go Monday to Friday. So would the court be taking this into consideration, or would just say, okay, it's not compulsory. So if dad wants to spend time with the child, then I shouldn't take him to nursery, or I don't know if that makes sense.
It's very difficult to answer sort of the question, if I'm honest with you, Ansi, because I don't know. Dad hasn't made the application yet. Okay, so if I were you, I would just be safe in the knowledge that you have a live with order, and to overturn that is going to be very difficult, if not impossible, for Dad to do. Okay, so be reassured that the child is always going to live with you. If you get to the point where the parenting plan hasn't been possible, relations are so far broken down that father then decides to go back to court, probably that's the appropriate time to come back and ask me the question, because then we would know what Dad was asking for. Okay, but right now, you're going to be fine with your live with order. Okay.
Yeah, and I can just use the help of the Kafka's person,
Absolutely.
if I speak to her about this. This what I just asked you as well. Maybe she can explain this better to the father,
That's right. You can ask her. All right. Was that helpful?
Yeah. Okay.
Fabulous.
Yeah, thank you.
Okay. Thank you, Ansi. Bye-bye.
Hi, Tracy. Can you hear me?
Hello. I can hear you. Yes. Hi. Welcome back.
Thank you. Hope you're well. So I'm going for a child arrangement order. In our last hearing, the judge ordered supervised contact for 2 hours a week, not supervised, supported contact for 2 hours a week in a contact center. But he also said that if me and mum can come to an arrangement, that contact can be either outside the center or it can be longer than the 2 hours.
Yeah.
Whilst we wait for the Section 7 to be done.
Yeah.
Since then, mum has said that she has concerns and that's why she was not willing to negotiate increasing the contact or doing it outside the contact center. But she refuses to share them concerns. What can I do in terms of negotiating? And if she won't negotiate, would that paint her in a bad light in terms of that she's not really willing to co-parent?
So a couple of questions there, Remy, and they're really great questions actually for other people that are listening as well. You're in the court arena now, so unfortunately, if you and her cannot agree, everything's going to go back to the court for them to make a decision. Within the court arena, if she has made allegations, it is your right to be saying to the bench, the judge or the magistrate, whoever's hearing your matter, I need to be told of these allegations, because she won't be allowed to simply say, I have concerns about my child's safety, but I don't want to share those concerns. She has to do that within the court arena. But part of your question was, how can I negotiate directly with her? If she's just not willing to share with you, my suggestion would be back off. Because what we don't want is for her to say, I had some concerns, I feel intimidated by him, and he kept pressuring me to tell him what those concerns were. You have to tread really carefully when we've got unknown allegations being made. But if it's the opposite and she feels that she can open up to you, then, or maybe use a third party and say, look, I get it. I get that you and I have to co-parent. We both have to feel that we're doing the best that we possibly can. If you have some concerns about me, please share them with me. Let me know and I can help address those. You're not admitting to anything, but you're just accepting her point of view and seeing if there's anything there that you can do to, quash her concerns, if you like. But of course, that suggestion is very much dependent on her being willing to talk to you in the first place. And my experience tells me that when we get to this stage and we're in court, they're not.
Well, you're right about that. Well, that was my last email to her solicitor, and they still refuse to share these, whatever her concerns are. On top of that, she's already made accusations, which in the last hearing, the judge said don't really affect contact, so there's no need for a fact finding. And it just feels like every time we go to court, she's bringing up something new.
Yeah.
And it just feels, what can I really do? At the end of the day, I don't even know what her concerns are at this point.
Well, and look, It's for you to remind the court that at the next hearing, we can't keep using court time without there being, some sort of productivity coming out of it. So what are those concerns? If she then shares her concerns, it may be, Remy, that it goes to a fact-find hearing, where you're both, she has to give written evidence of her concerns, and then you have to give a written answer to those concerns. And then there's a hearing, and the judge will determine if there's any truth into what she's saying. And even if there is truth, if those concerns are shared by the court. Because that's the other thing. Sometimes when people say, I have a real concern, I don't want my children meeting their new partner. That isn't a concern, really. So the court will dismiss that concern. So if she's refusing to give information or what these allegations are, press the court to order her to file what's called a schedule of allegations. It's that straightforward. That's how. Go on.
That's the thing. We've already had that. We've already had her Scott schedule. We've already had me reply to it and give evidence.
Yeah. So you've had your fact find hearing then.
New stuff. No,
okay.
The judge said it doesn't. Accusations don't affect contact, so he doesn't feel the need for a fact finding.
Okay. Well, then at your next hearing, the court has to now be told that despite the court's indication that these allegations don't warrant concern, mother is still using these allegations to prevent you from having contact. And the court will then deal with that. And how they deal with that is that they will order contact to take place, hopefully unsupervised contact. And you might want to even suggest to the court that a penal notice is handy, so that if she continues to breach the order, that there's consequences for that.
Oh, she hasn't breached the order. It's just
no, she hasn't breached it now. She hasn't breached it now. But I mean, when you go back and you suggest to the court that, she's still not allowing contact to move forward because of these allegations.
Okay. Yeah, that makes sense.
It's a painful and long journey. And honestly, I wish I could tell you something different, Remy. The family court is particularly painfully slow at the moment. It really is. But all you can do is wait your 3 months or however long it's going to take you to get your next hearing date, and then let the court know, look, she is still frustrating contact based on allegations that we have already dealt with. The contact now needs to move away from being supervised or whatever it is. We need to be out in the community. I need the contact time extending or more frequent or whatever it is that you're asking for, Remy. And eventually the court will listen to you, particularly if you've had a fact find. The sad reality is, and I say this to you, Remy, but also to all the other fathers out there that are listening, that so many people are aware of how slow the family court system is and they're abusing it. And that's what you're being subject to. That's the reality of this, really. All right.
Thank you, Trace.
No problem. Nice to hear from you. Take care. Bye.
Hiya.
Hello.
So my husband is going to divorce me, and immediately the first thing I did was apply for a home rights notice.
Yeah.
And that's come through. That's all successful. That's grand. But my concern is obviously that I lose that once the final order gets served, basically. And he knows this, so he's kind of stonewalling any kind of financial order by consent, even though that's ideally what I'd like, knowing full well that I can't ever stop the final order being warranted. And the only thing I've got here is that he really wants me to move out. So once I lose my home rights, and then I have no kind of right to stay here, I kind of lose any upper hand I have in trying to organise a financial order. Obviously, I'd happily apply for the court when the time comes round, but that's going to take a very long time, and then I've lost my home rights. Is there any way of getting that extended?
What do you mean you've lost your home rights? So you've
I haven't yet, but I will do once the so his solicitors advised him that once the final order comes through, I no longer have home rights.
That's not true. Your
Okay.
HR1 stays with Land Registry until you make an application to remove it. You can
Oh,
go ahead
really?
and get, yeah, absolutely. You can go ahead and get the divorce. I wouldn't advise it, by the way. But getting the final order in divorce will not remove a HR1 from Land Registry.
Oh, okay. Because he was telling me, well, he'll just wait for the divorce to be kind of finalised, and then I lose my home
No.
rights.
No,
Okay, well, that's grand then.
unless he got mixed up and he was talking about the financial order, but that's what you want, isn't it? The financial order. So
Yes.
you're going to embrace
Yes.
that. Yeah, no, the divorce won't automatically remove your HR1. Absolutely not.
And does it expire at all, or is
No.
it just until I take it away?
No, it will stay there until and then you've got to make an application to remove it. And the process to remove at the moment, I think it's taking about 3 to 4 months. I mean,
Oh, okay, fine.
so
I'm
is
not
so is
as
the
worrying as I
process.
thought then.
So is the process to register it. Unfortunately, it's taken an awful long time. But no, you should be fine, Megan, if it's just the divorce you're talking about.
Okay, lovely. That's grand then. So I've got a bit more time on my hands.
Oh, pleasure. No problem. Glad I could help.
Thank you.
Thanks,
Bye.
Meg. Bye.
I'm currently also on the court stage where my ex-partner is trying to get a non-molestation, and where I've addressed to the court, I have two options. First, that I'm challenging because she's not truthful in front of the court. And the second thing is that I'm not challenging it, but I just disagree it to be in a one way.
Sorry, I'm not understanding your question, Jean. I'm so sorry. So you are defending a non-molestation order. Your claim is that she's obviously not being truthful to the court. But what was your second statement to me?
So now after that, once it's gonna be finished, the final decision of non-molestation order, I know that she will be going for family court in terms of to decide who the child live with, the hours, how many hours I can see him, and stuff like that. So I wonder how high is my chances in terms of that. I can get 3.5 days to see him, as much as she do, and basically to have equal rights as she have in terms of the parenting.
Yeah. Okay. So two questions there. So that, in other words, if the non-molestation order is made, how is that going to impact any child arrangements order decision that the court might make? Is that right?
If I prove that she's not truthful and she doesn't need the protection, however, I'm not against it, right? That if it works for both of us, then next she will be. What I'm trying to say, she's trying to look me bad for the next stage of a court for the family court, right? And then say, can I get more rights than the father because I have non-molestation on him.
All I would say to you is that, look, the non-molestation order is given where somebody feels that they need protection from the other adults, okay? It's not often that there's not often an inference drawn when we then go over to children's court. Okay, so let me give you an example. Oftentimes, two adults who no longer want to be together because they just don't get on for whatever reason, and there has been maybe domestic violence within the relationship, as soon as they separate, that toxic relationship ends. And the family court deem the children to have no welfare concerns. So as soon as we separate the toxic parents, they can then be great parents in their own right. So it doesn't always have a bearing, okay? Now, I'm not specifically addressing your case because I don't know anything about your case.
Yeah.
So I don't know any of the allegations that she's made or the evidence that she's used. But it seems to me already that the family court who are making the non-molestation order are already foreseeing that you two have to co-parent. And that's why they're building in provisions to enable you to have a parenting WhatsApp app or whatever it might be. So, which then tells me that an application for a child arrangements order is most likely going to be successful. Whether she makes it or whether you make it, I would have thought that you would make it. And the reason I say that is because the law is very clear, and it says that it's the children's right to have a relationship with both parents. Okay? So I would tackle your non-mol, obviously defend it as much as you can. It may be that no non-molestation is made and that both of you give undertakings instead, and then move on with your child arrangements. But I suspect, based on what you've told me, that already the court are building in an ability for the children to have a relationship with you.
Right, yeah.
Does that help?
So does it matter who? Yeah, but does it matter who goes first to file the child arrangements and everything?
Well, I mean,
to a family court.
I'm just going to throw
for
it out
example,
there.
I know that she doesn't have to pay for it, but then
Okay. There's every chance that she isn't going to be making an application for you to have lots of contact with the children, is she? If the children are in her care, there is no need really for her to make the application. What motivation has she got? So I would invite you to make the application for the child arrangements order if you feel that you want more contact than you and her can agree on. Do you see?
Right. I see. Yeah. So, for example, the court order could say the certain days is like have a right to have him, and nobody can say no.
Correct.
Okay. Right.
All right.
Okay. Thanks.
I hope that was helpful. Thanks now.
Hello.
Hello.
Thank you. I'll just quickly explain. So we're getting separate. We're separated. We have a house that we jointly own. I pay the bills. He pays the mortgage. The house is halfway through renovation. So he is going to take out a loan. Was taken out a loan to finish the house because he wants it sold. Obviously, I'd rather keep it and happily pay half towards the mortgage because I've got 2 GCSE age children. I don't really want to have this upheaval. So I've sort of got 2 questions. He's got a loan to do home improvements since we've separated. If we end up selling the house, will that loan be put into the pot so that it then it's like the matrimonial pot because it's not a joint loan, it's his loan? How does that work?
So if he's actually used the money to improve the home and then you remain living at the home and therefore benefit from those improvements, yes, that will be seen as a matrimonial asset.
Okay, thank you. If the house doesn't get sold, if they decide that I can stay and pay half towards the mortgage to do his pension offset and everything, and the house doesn't get sold, it doesn't get sold, so there's not a pot sort of thing of equity, will he then be liable to pay that repayment, or do I have to go halves on that?
That's going to depend. That's more of a question that warrants an appointment, because in order to answer that question, I would kind of want to know, and please don't answer these questions, but I would be asking you, what do you earn? What does he earn? How much equity is in the house? How old? Well, you said they were GCSE age, so I'm taking it they're 15, 16. So that's when we would start to look at those Section 25 factors. And of course, then it would depend on who's got more disposable income. Does it mean that he gets a little bit more in the equity when the house is sold because he's going to repay the loan? But that's a question that would be very specific to your case and something that would come out when we're giving advice.
Oh, okay. Thank you.
That's okay.
And so if I got a loan now, like we're separated, but my loan is to pay for my divorce, how does that work in both those instances, sort of?
Yeah. So then that's your loan. That wouldn't be classed as a matrimonial debt. Yeah. And the easy way to think about matrimonial debt is, regardless of whose name it's in, did you both enjoy the debt? So with regard to the home improvement loan, you will enjoy that. He may not, but of course the loan's in his name. But with regards to the loan for your legal costs, he won't have enjoyed that. So that's the easiest way to sort of think about it.
Yes. Okay. Right. Okay. Right. Okay. And how often? I know this is another bit of a tricky question, but because each case is different. But how common is it, like measure orders and stuff like that now? Is it just totally down to each case?
Sorry, did you say national orders?
Oh, measure orders. How are they not very common anymore? Or?
Yeah, no, they are. I mean, the court's preference currently, and of course it changes all the time, but at the moment, the courts seem more keen to do clean breaks. Whereby the parties, and I think the reason for that, if I can just give people some context, is because where we have financial orders, where there's ongoing events that are going to happen in the future, such as your measure order, if communications break down, the matter comes back before the court. And of course, the court's trying to think of ways to get things out of their list. So there is a kind of, it's fashionable at the moment, or it's just, in practice, we're not seeing as many measure orders as we used to for that reason. But that's not to say that the court aren't making the measure orders where there's a genuine need for them. A measure order, you obviously understand that, is for the benefit of the children, essentially. It's not to benefit one adult over the other. So where we have children's housing needs, then of course the measure order is still going to be considered and placed on the table.
Yeah, because I just think if, obviously, say he's got more earning potential than I have, to get a house to house me and the children in a similar area because they're at schools around here, I just feel, I don't know how that works. Because if you have to sell your home.
Yeah, and of course that goes towards your argument. So where we have one party that's got a good mortgage raising capacity, we are arguing or suggesting to the court that they take less of a deposit because they can raise more by way of a mortgage. And where we have a person that has lower income and therefore has a weaker mortgage raising capacity, if we were to sell the property then and give that person with zero mortgage raising capacity a lump sum, what good is it to them? And this is where the argument for the measure order then comes in. But again, it would need, to give you a solid answer, I would obviously need to speak to you off air via an appointment. And then I'd be able to say, this is your prospects of success, or, it's not going to work, whichever.
Okay. Do I email you?
You can drop me an email. Yeah, absolutely. You can drop me an email. Let me know. Just remind me that we spoke on Discord. I do get a lot of emails and I'm pretty good. I mean, usually within 24 hours, I'll be able to answer you.
Oh, thank you.
All right. Absolute pleasure. Take care. Bye-bye.
So me and my ex-partner are currently separated. We've been separated for a while.
Yes.
And we have been voluntary using a parenting plan, which he now wants to change. I understand it's not legally binding. We've not gone to mediation yet. We're in the process of that. But my question is related to safeguarding, and basically if an incident of safeguarding is incurred, so say a drug issue, I'm trying to put together a plan to put forward in mediation. But in the short term, until we get to mediation, I'm trying to implement some sort of like drug testing agreement, which he has been instructed by solicitor to not sign any documents, which will just be voluntary between me and him. But it's just to show that he's willing to take drug tests and he's willing to show some sort of consistency, so that if we were to get to court, it's in his benefit to kind of like show that. We have been doing drug testing, but he has failed drug test. We're waiting to see whether or not this is classed as a false positive from the supplier. So I have been supervising visits since. Legally, where do I stand in terms of supervising them for how long? Because he's really forceful now. It's been a week and he's since proved that he hasn't been under drugs. But I'm still pushing that those visits need to be supervised because of that incident where he has failed 2 drug tests.
Yeah, again, I think that it would be helpful, and please don't answer this question while you're on air, Rose, but it would be helpful to know a little bit more about those concerns, the type of drug, the volume that he uses, and how that, impacts his ability to have the children. What I mean by that is he a recreational user? Is he just using drugs maybe Fridays and Saturdays, and then he's having contact with the children on Wednesdays, for example? So, a bit more context is always useful if we're going to give a specific advice. But in order to answer your question about time, typically when we're in the court environment, we are looking for drug results and going back the last 6 months. So if we get a positive drug result and it shows that for month 6, 5 and 4, it was clean, but maybe, the last 3 months we're using again, then we're going to be starting again. Because the difficulty when we come to addiction, whatever addiction it is that we have to see a period of consistency. It's not good enough to provide a clear drug result and then a week later say, great, that's clear, and now I'll start contact again. We need to ensure that there's consistency. Now, the length of time of the consistency will be determined by the severity of the addiction. So going back to my previous sort of statement, that's helpful to know. Are we talking class A? Are we talking recreational? Because that's very important, and that will help me sort of say to you, the court's going to want him, consistent for 3 months or 6 months, or if it's really bad, a year. Do you know what I mean? But definitely more than a week. Definitely more than a week.
Yeah. I think he's just trying it, and I completely understand why he would be, but it is about the safeguarding, and there was risk to harm with our child, hence the reason why we went into supervised. But I really appreciate your advice. Thank you so much.
Our absolute pleasure, Rose. You take care. Thanks now.
Thank you.
Bye-bye.
Good afternoon, Tracy.
Hello.
If one party is in England and the other is in Ireland, baby lives in Ireland, where does the financial order start?
Oh, because you said baby, I thought you were going to say, where does the child arrangement start? The answer to that question would be Ireland. So the baby has no relevance. The financial order will start by whichever country starts the divorce. So if we've started the divorce in England, then we have jurisdiction to do the finances in England. And if we start the divorce in Ireland, we're going to have to ask for permission to do the finances in England.
Okay, that's great.
Thank you.
Can I request that my PR is removed?
Can you request it? You certainly can request it. I think the better question there is, will you succeed? And chances are you won't. We'd obviously have to look into why you are looking to have parental responsibility removed. But the courts do feel it's important that a child has two parents, both of which have parental responsibility. Regardless of what the relationship is between the parents, you are parents. So if something happens to one of you, then the other parent will be called upon to step up. So, chances of having your PR removed is difficult. Jack, I'm going to come to you. What's your question, Jack?
We will be approaching a final order at the end of the year. The likelihood of things changing to what we wanted.
Yeah.
It is quite unlikely at the moment because little one is only 9 months. Settling is still quite hard.
Yeah.
How does variations orders work, and how long do you have to wait before you make them?
Sorry, Jack, did you say the final order or the financial order? Sorry, I missed that part.
So a final hearing.
Final hearing, sorry, beg your pardon. And what are you in court for, children or finances?
Yeah, so it's a final hearing at the end of the year.
Yeah.
And the idea is that most likely the outcome isn't going to be what I would like. So next year it would be making a variations order. It's just about understanding how long you'd have to wait, how long they take.
Oh, I see. From when a final order is made, give it a couple of years. Give it a couple of years, unless you can submit your evidence to convince the court that there should be a different final order made, and it's made, then yeah, I'd give it a couple of years before you go back to try to unpick that.
Okay. So because it's only like the little one will only be like 18 months by the time the final order comes.
Right.
So if the relationship does build quite a lot, obviously, over the next like year or two between that, then I guess that's when you'd go back.
But if you're going back, Jack, because you want increased contact, you can build that into this final order. Do you want to give me some more context, if you can? What it is that you would be going back to change?
Yes, at the moment, it's 2 hours a week that we're getting with everyone. Grandmother is doing 1 hour, and the other hour is supervised by a family practitioner that writes notes.
Yes.
The idea is that because little one doesn't settle with me fully at the moment, because she's still got quite a strong bond with mum, as expected, because mum is the main carer and is all that she really knows, she finds that settling quite hard. So the idea is they're not really willing to extend times or anything like that, because they're saying that she comes to emotional harm from crying and not being at ease with me.
Yeah, it sounds to me, and I'm no children's expert, but that's just some separation anxiety. Because she's only seeing you for 2 hours once a week and she is 9 months old, I totally get that. But my personal view to that, and if I was representing you, would be my suggestion to the court is that we up the contact. We don't keep it at 2 hours. We have 2 hours, maybe 3 or 4 times a week, so that she can get used to you. That, to me, would be the more logical approach to this.
So then the social worker that she has got, and then mum, is also saying that because she's coming to that emotional harm in those 2 hours, they don't want it to go any further.
I disagree with that, and I would be asking social services to put forward evidence that actually, she's coming to social harm. How many parents drop their children to nursery at that age every morning, and the children scream the place down because it's separation anxiety? There's no mental harm there. The parent has to go to work. I'm not buying that, Jack. Sorry, I'm totally supportive of what you're saying.
But they said, from what was explained in like core group meetings and stuff, it was that time with dad is traumatic.
I'm struggling to hear you, Jack. Sorry, you're going to have to say that. The reception's so bad. Sorry.
I said that, so they say that time with dad is traumatic for that reason alone.
Time with dad is traumatic. Okay. Well, I would beg to differ. I would say that it's not actually the time with dad. It's the time with anybody. It'd be interesting to see how she would be if she was left with a babysitter for 2 hours, or if she was put in a creche for 2 hours, or she had to, be left with a nanny for 2 hours. I do think that you are being made to be the villain here, when actually we've just got a 9-month-old. And I would be really pushing, rather than waiting your 2 years, Jack, and then going back to court, I would be pushing for additional time as she gets older. So if it's 2 hours at 9 months, I don't know, maybe, 4 hours at the age of 1. And then 6 hours at the age of 18 months or whatever it is. I mean, children... Sorry?
We've put all of that in our position statements of a complete transition over a 42-week period to try and achieve a shared care arrangement. And it's just kind of been shut down so far.
Well, it's being shut down by the other side, but you haven't reached your final hearing yet. Okay, so I think the thing is, you've got to stay positive. You've got to throw at it everything that you've got. You've got to get a really good legal representative with you on the day, a barrister who can really, you know, who's got a track record in winning these types of cases, who can convince the court that actually it's in the child's best interest to have a great relationship with you. And the only way she's going to have a relationship with you is if we increase contact. Because right now, for the 2 hours that she sees Dad every week, she's crying because, quite frankly, she probably doesn't know who you are, really. You know, 2 hours a week for a 9-month-old, it's just not enough, is it?
I mean, we have like 3 hours on FaceTime. In every FaceTime, she's calling towards the camera, she's laughing, smiling, or always queuing. So that part's all there, and like you get some settled sessions, some that aren't settled. But at the moment, they're just not using it enough.
Yeah, I just think that's children. You know, there could be days where she's tired, she's grumpy, she doesn't want to, you know, I don't know. All I'm saying is it's not you. You know, you're her father. It seems to me that you aren't a risk to her. It's just how she is around you. She'll grow out of that. And the court can't reflect that in a long-term final order, would be my suggestion.
Okay. All right. Thank you so much, Tracy.
Pleasure. All the best. Thank you, Jack. Hey, Captain.
Hello.
Hello. Did you have another question for me?
I did.
Thank you.
My child's father and I are in a dispute over some of the details in our CAO regarding the children's expenses, which are to be shared by both parents equally. The children's father is using his solicitor. I'm representing myself, providing timely and professional responses to his solicitor's email. His solicitor has not acknowledged responded to my last 2 emails asking for an explanation as to why previously agreed expenses are now being disputed. I assume professional courtesy takes place regardless of legal representation. Do you agree? I am sure if I had appointed the solicitor, I would have received a response. Appreciate the solicitor may be waiting for instruction from their client, but they aren't communicating with me at all.
So it's difficult, isn't it? Because if a solicitor doesn't have instructions from their client, then they've got nothing to tell you. And some solicitors will write to say, I don't have any instructions, I've got nothing to tell you. Or some solicitors just don't. They're not, yes, courtesy would maybe suggest that they should, but some solicitors are so busy, they are just dealing with the clients that are providing them with instructions. So if a client isn't providing you with instructions, you move on to one that is. But when it comes to things that are recorded in a child arrangements order, as is this one, we have expenses, child expenses. If that's not being complied with, then it might be that it needs to be brought back to court for a fix, for a better fix. Maybe a lump sum of money could be ordered rather than having to, you know, obtain these monthly amounts that aren't being paid, or whatever the situation is. I mean, I'm guessing because I don't know.
No worries. And then the final question I've got for now.
Yes.
And it's more just asking for your thoughts as a family lawyer. Someone put on TikTok, I think we should have juries in family court. What is your opinion?
Oh, that's a great question, you know. I disagree, though. I completely disagree. The reason we have juries in criminal courts is because we want to get the view of the everyman. We want to get the view of the man on the street. You know, has the case been shown beyond a reasonable doubt? Have the prosecution shown that? In family, it's very bespoke. It is between that couple. It is within that family. And I'm not so sure that people's general life experience would be able to assist. Life experience helps us in crime, and generally most juries will be of all different ages, you know, all different, obviously both sexes, but all different, you know, cultural backgrounds, because we are looking for a wider view. But in family, it's very bespoke. I personally wouldn't be an advocate of that. I think it should remain private. Another reason why I don't want juries involved in family court is because we don't have legal aid for family anymore. And what that means is that people who can't afford a solicitor have to represent themselves. A lot of people who represent themselves, we call them litigants in person, are already intimidated by the court arena. The last thing they want is have to walk into a court and then be faced by 12 members of the jury. So it would definitely be a no from me, but great question.